Thank you.
Good morning, Mr. Parsigian.
Good morning, Your Honors. May it please the Court, Ken Parsigian, representing Phillip Morris USA, the appellant, with me, Michael Murray. Let me begin with the exemption under Chapter 93A, Section 3, for conduct that is otherwise permitted by a federal or state regulatory agency. The motion judge here correctly ruled that the Federal Trade Commission permits the use of the descriptors that are challenged in this case within the meaning of 93A Section 3. The motion judge took a wrong turn, however, when he ruled that the exemption still didn't apply to Philip Morris's conduct.
But haven't we said that we need to see, for the exemption to apply, there has to be affirmative action by the agency?
In the Fletcher case, Your Honor, this Court said it has to be affirmative permission.
Right,
and
so
we believe there is affirmative permission
but
here.
what you've shown, it seems to me at least, is what you've shown is inaction by the FTC, not action.
I would disagree with that, Your Honor, and the motion judge disagreed with that, and let me explain why. In 1967, the Federal Trade Commission issued a policy statement about what its policy was on representations of or relating to tar and nicotine disclosures. That's their word. They reported that to Congress in 1968 in their annual report. It was an official policy statement of the FTC. And what it said is that representations relating to tar and nicotine yields, and that's what we have here, are allowed provided they are substantiated by the FTC method.
Are allowed where?
It doesn't limit in any way where they're allowed in that policy statement. It simply says they will not be challenged as deceptive practices provided they are substantiated by the FTC method, which is a machine test method that the FTC developed and requires the manufacturers to use to this day in reporting tar and nicotine yields to the public. So that's the policy statement in 1967, reported to Congress in 68, and repeated to Congress later than that. And I want to take just a minute to take it to the next level and say, even today, we just submitted last month the testimony in December. Just a few weeks ago, we submitted a supplemental submission on the testimony of FTC Commissioner Kovacic before the Congress. Senator Lautenberg held hearings on the use of descriptors. And what Commissioner Kovacic said is that the key question for all of us is whether there is any significant subset of users, of smokers, who do derive useful information from these standards and change their behaviors in useful ways. And he said, I oppose any ban on descriptors as they're currently being used until there is a conclusion that there is no benefit.
This
But
is
in
still
19
their
but
policy.
in
This is
20
one FTC commissioner?
Excuse me?
This is one commissioner?
That quote is from, you're correct, Your Honor, that is one commissioner, but he was delivering, let me just explain, he delivered a written statement on behalf of the FTC, a formal statement. That was his quote in talking about the formal statement. So that literal quote does not refer to the whole.
As a practical matter, why do the cigarette companies fight this if they don't have something they don't want to disclose? Alcohol manufacturers and beer and other kinds of things got to put the percentage of alcohol on the bottle or the can. In food products, sugar, all kinds of other things, fruit syrups, every ingredient is disclosed. Why do these people fight this?
Well, Your Honor, I don't think
I mean,
it's so
they're
much.
selling a product that's been condemned universally throughout the world, that's killing people every day.
Your Honor, let me say, the cigarette companies are not fighting whether it has to be on the pack. They have never been told it has to be on the pack.
Well, let
The
me ask you
FTC
this.
Then why don't they put it on the pack?
Why in 2002 did you petition the FTC and arguing that the FTC should adopt a rule expressly authorizing the industry to continue to use such descriptors? If the FTC had already done so, wouldn't that request be unnecessary?
No, Your Honor. If you look at not just the language quoted by the plaintiffs, the one sentence that you just read, but you look at that section of the 2002 submission, It flatly says, by Philip Morris, the FTC has always permitted the use of descriptors, but they said, in light of the new science, you ought to reevaluate it and make a clear statement so that we don't wind up with the very problem we have today, which is we have courts, Supreme Court of Illinois finds specifically authorized, the FTC specifically authorized the use of these permissions, these descriptors, overturned a $10.1 billion judgment for that reason. Federal District Court in Michigan, Federal District Court in New Orleans find that, and yet we have the First Circuit in Maine reaching some different conclusions. It's specifically to avoid that problem that Philip Morris said in 2002, look, FTC, you have always permitted it, but in light of the new science, in light of the allegations, you ought to take a look at it, and you ought to say clearly so everyone knows, say it again.
But some of the cases that you relied on in your brief, I noticed, have since been overruled. The Court of Appeals of Minnesota overruled the Dahl versus R.J. Reynolds, and the Federal Circuit Court overruled the Good versus Altria group. So it seems that the courts now are coming around the other way.
Well, I wouldn't say that, Your Honor. The most recent decision is the Pearson decision in Oregon, which looked at both the Good decision from the First Circuit, which goes one way and is currently cert pending before the Supreme Court. We'll have a decision from the Supreme Court on cert on January 22nd. And the Brown decision from the Fifth Circuit, which is in direct conflict with Good. And the Pearson court found that Brown was right. So the courts have gone both ways on this. I don't deny it. You've cited a couple examples. I've listed other examples. But that's the very point, is that there's supposed to be uniform standards with respect to cigarette labeling and advertising, not 50 different standards from 50 different states.
As a matter of prudence, if in fact the Supreme Court of the United States is going to get involved in this, because there's, as you say, two conflicting circuit opinions, one apparently going in favor of the plaintiffs and one going in favor of you, we should sort of defer ruling on this, shouldn't we?
Well, Your Honor, the 93A Section 3 exemption,
well, no,
of course, is not before the Supreme Court. And that's why I've chosen to focus my remarks on that rather than on the preemption issues, which are before the Supreme Court on a cert petition that we should hear more on recently. If I could get back to answering Your Honor's question, Justice Franey, let's be clear. Since 1970, every single print advertisement for any cigarettes has carried the mandated statement from the Federal Trade Commission about how much tar and nicotine.
But not on the packages.
Yeah, I'm answering Justice Franey's question about whether the manufacturers have resisted providing the
But the whole question is, everybody agrees that you have it in your signs or billboards or whatever you have where you're allowed to have them. But the whole question is whether they have to be on the packages.
And the answer to that, Justice Cowan, is this. Let's look at not only the policy I just stated to you from 1967, which does not in any way require that they be put on packages. Number two, let's look at the 40-year implementation and interpretation of that policy by the FTC.
Can we start with the 1970? If you're talking about affirmative action, it seems to me the 1970, whatever we called it, voluntary program, right? And
Yes,
so
ma'am.
we have, I take it, that you have in all advertising, in newspapers, magazines, other periodicals published and distributed in the United States, including newspapers, magazines, and other periodicals distributed primarily to members or units of the armed forces of the United States located abroad, and advertisements appearing in billboards in the United States, and advertisements appearing in printed on handbills and direct mail circulars that are distributed to consumers. I take it that the tobacco industry has complied with that.
Yes, and it is undisputed.
And it says absolutely nothing about individual packets.
It
correct?
says absolutely nothing about individual packets. That's
We
correct.
also know that the FTC enforced that against at least one manufacturer.
That's
right?
also correct.
And came to exactly the same conclusion, correct?
Correct.
We also know that this is a highly regulated industry.
Correct.
I
One of the
couldn't-
most highly regulated.
And I don't see anything in there that talks about packets.
It specifically excluded packets, and there's a reason for that.
Did it specifically exclude packets?
No, I mean, it specifically chose to leave packets off that list, and there's a reason for it. There's a very clear reason for it. In the Federal Cigarette Labeling and Advertising Act, Congress forbid anyone but itself from requiring any additional information about health, smoking and health.
Well, of course,
on
the other
cigarette
side
packs.
argues that this isn't health and smoking, this is a deceptive practice, this is a fraud.
Your Honor, the statement, first of all, I would disagree with that. It can be both, and Cipollone, the Supreme Court decision, makes clear it can be both about fraud and about smoking and health, and we can get to that later. But the statement, should we be required, did the FTC require cigarette manufacturers to put tar and nicotine numbers on packs? The FTC has said expressly to Congress and publicly that it has never required that. I cited in my briefs the 1979 report to Congress where they said we have never required tar nicotine numbers on packs.
How about the
And
1996?
Congress does not allow them to do it. Yes, Your Honor.
And similarly in 1996.
And similarly in 1996, they said it again, it has never been required.
Well, I think Justice Graney's question is a very good question. I'm not sure I understood your answer. If you are required and you do comply with putting the numbers on all your advertising, and cigarette packages presumably are advertising, at least to some extent, that I realize that's a question, but why are you fighting putting it on the packages?
I would disagree
Well,
with
you're
the
here
premise.
contesting it, so you are contesting
No,
it.
I'm contesting whether it was required. That's what I'm contesting, whether the FTC required it. The question before this court is, did the FTC permit us to use descriptors on packs without the numbers? The FTC's 40-year history, all its public statements, unless you believe the FTC has simply neglected to enforce its own provisions, it plainly allows it. It has allowed the widespread and open use of descriptors on packs without the numbers. That is not the same thing, Justice Cowan, as saying that we are in any way fighting it. If Congress passed a new law saying it was required, and I would note,
Which is
Congress
why-
was asked multiple times, 13 years in a row, asked to require that on
Michael-
packs, and it said no.
Am I correct, Mr. Passigian, that the reason why on food products, for example, there's a listing of the fat content and the everything else, and on, all kinds of other things, it's because that is required, correct?
I would expect, Your Honor, that it is required in the vast majority. There may be some examples that I'm not aware of, but generally there is a requirement
That
that
they
it be
do
put
that.
on food products,
Well, I
and
guess
so
what
they
I'm
comply
saying-
with the requirement.
I wasn't talking about the legalities of the case, on which we certainly will have to decide it on, but I was saying as a practical matter, why don't they just step up? What is their problem?
Well, Your Honor, I am not going to purport to know exactly why the companies have not done it, but let me offer a few things that I do know. Congress, as I said, was asked 13 years in a row to require these numbers on packs. And the legislative history shows that the reason Congress said no is they didn't want to confuse any messages about what their health warnings say. So even Congress didn't think and hasn't thought it was a good idea to require it. So there are reasons that people who are concerned about health make a decision
But that
not
makes
to do
no
it.
sense, because it's in the advertising and whatever magazines and wherever other forms of advertising are sent out. Doesn't that confuse people?
No, because
but
those do not have the warnings. Am I correct?
No, the warnings appear in the ads,
warnings
Your
are
Honor,
there,
but what
too.
Congress has decided is that on packs, the warnings are the one message they want to get out. And that's why Congress did it that way. The other thing, Justice Graney, is simply that it's in the ads. People who smoke these products read it in the ads. There's not a lot of reason to suggest that people don't understand what it means. The terms, lights and lower tar nicotine, are simply shorthand versions of communicating the same message. And I would note one thing, one other possible explanation. And I say this is only a possible one because I'm not purporting to know why the decisions were made. If we look at the Barclay decision in not the Barclay decision, the American Tobacco decision in 1995, the FTC challenged the use of representations by American Tobacco because they weren't substantiated by the FTC method. So when they have a problem, they challenge it. And
What do you say to the fact that the federal government prosecuted your company in United States versus Phillip Morris, USA, Inc., claiming that the use of low tar descriptors was false and misleading?
Well, that was the Department of Justice's position. That case is on appeal. But I would say that That was not the Federal Trade Commission, which today, still in the wake of that decision, uses the FTC method, continues to permit the use of descriptors without the numbers on packs, continues to require the cigarette manufacturers to report tar nicotine numbers according to that system. In the wake of that, they still do that today, Your Honor. I see that my light is on. If there are any further questions, I'll take them.
Thank you, Mr. Pasajian. Mr. Hammond?
Good morning. May it please the Court. My name is Todd Heyman. I'm here for the plaintiffs' appellees. With me is Tom Ermey. I'd like to make
Before we
one...
get too far into this, could I just clear something away? On the federal preemption point, in view of this possible cert thing, if cert is granted, should we just, forget about that for the time being and just decide the 93A point?
Your Honor, our position is that the Court should chime in on the preemption issue. It's a shallow split. It's just the First and the Fifth Circuit. There's a handful of decisions on express
I
preemption.
say we wait and see if cert's granted. If cert's granted, we know one side or the other's going to win, right?
Correct.
So,
Are you suggesting...
Well, obviously, it's up to the Court whether or not you want to chime in on the preemption issues if cert is granted.
I'm asking you for your,
Our position is we would like the Court to chime in on that.
Okay.
What is
I'm not
your
sure
response to Philip Morris's claim that after the American Brands Consent Decree in 1971, then when the FTC found violations by American Brands, they went after American Brands brought enforcement actions against them, but they never brought an enforcement action against them, against American Brands for using the descriptor lights or on the packages without the tar and nicotine numbers.
Well, Your Honor, I think the key to the answer is exactly what you said. They never brought an enforcement action. And as Justice Spina said,
And you're
What do you
saying
mean
that's
they never
not,
brought
that
an
means
enforcement?
they never
didn't.
brought an enforcement action is not affirmative permission, Your Honor.
Yeah.
The lack of
What about the voluntary program? What about all the representations? I mean,
Okay, Your
I mean,
Honor, if
if-
I may, I'd like to back up
Sure.
because the facts have been grossly misrepresented. I want to start in 1997, in the
Why?
class period, not 35 years ago, because the position of the FTC is clear during the class period. In order for you to rule against us, you would have to ignore the fact that in 1997, during the class period, the FTC said they don't have an official position on these descriptors. The President's Cancer Panel has recommended that they be regulated. They're beginning the process. They put this in the Federal Register. They're beginning the process of determining whether or not there should be, and they asked the question, should there be guidance, official guidance from the agency on these descriptors? If yes, why? If no, why not? And the
Mr. Heyman, I can understand why you want to start in 1997, but at least as I have looked at this, this is what has happened. There have been at least two things happening here. One is the FTC-sanctioned method of determining, what the tar descriptors will be is under significant challenge as to whether or not that's how much a smoker intakes, right? We've had that before. You put your fingers over the holes. So there's a big fight in the scientific community about that, as to whether even these descriptors are meaningful. Am I correct?
Our position is they're meaningless, and in fact, the federal government proved that they were false in the federal racketeering action.
No. So putting on what you are saying they should have done as a way of making any difference in terms of what an individual smoker actually inhaled was not going to be helpful, correct?
No, because our position isn't that they should have put additional information on the packs. Our position is the representation, lowered tar and nicotine, is false, and that's exactly what the United States District Court for Columbia found. Philip Morris has never addressed it. It was a 9-month bench trial, all expenses out, and after that bench trial, they found they were false.
Has the FTC allowed, because it hasn't challenged and entered and accepted a voluntary program that permitted those descriptors?
No, the FTC has never allowed it, and maybe that's where I should start. Why do we need dozens of pages describing everything the FTC ever said about tobacco in the 20th century? If the FTC allowed this, why can't Philip Morris just cite to the place where they did? Now, they've offered, originally it was the 1971 consent decree that they said allowed this. The 1971 consent decree explicitly says you cannot use these descriptors, low, lower, low tar, unless you use the numbers with them. It
But
says
how
that.
does it include cigarette packages?
No, it does not say that.
It does say that. It says it on 1277 of the record. I don't have it in front of me, Your Honor, but the first paragraph of the order says you cannot use the terms low, lower, or reduced unless the tar and nicotine numerical ratings accompany that representation. It's right there.
It says it in advertising, and I've read it carefully, but how does that language, this is the whole problem, it's
Okay, well,
vague.
I'm going to explain that then.
How does that language include cigarette packages?
Okay, if we think advertising includes packages, but even if
But
it
it
doesn't,
That's the
doesn't.
question, is whether...
okay, even if it doesn't, it still does not permit the use of the terms. And think about this. In 1969, they brought a complaint against the American Tobacco Company. They said these terms were false and misleading in the complaint. They prohibited their use unless they were accompanied by the numbers. That's what the FTC said. To interpret that decree to say that it permits them on the packages, you'd have to find
You're
that
talking
the
about
FTC
the American brand.
I think you're
decree.
over-arguing your position. The mere fact that they said you have to do it in advertising does not say you don't have to do it on packaging.
And it doesn't say you
Therefore-
can do it on packaging.
Correct. So therefore, there's no preemption or no conflict under 93A.
That's
the
absolutely
point.
correct. It's the absence of permission. Even if it
Yes.
didn't apply to packages, it didn't permit them to use it. And so what happens? That was their first argument, 1971. First they said it permits it on packs. Now they say it doesn't apply to packs. Now, so
Well, the
where are we
question
going?
really is whether packages are advertising, that's all. If we say packages are advertising, that it's included within the consent decree, and that's the
Well,
end
if
of the
it's
question.
included within the consent decree, then they were prohibited from doing it. But
Right.
let's back up, because the consent decree clearly doesn't say you can use these. It says the exact opposite. And in fact, the FTC provided testimony in the racketeering action in which this was specifically addressed. The FTC said, and I am quoting, and this is in the Flanagan decision, the 1971 consent decree does not affirmatively permit anything. What this order does is say you can't use any of these terms unless you provide a disclosure of the tar and nicotine content. That's the Flanagan decision in Michigan. That's what they said. There's absolutely no dispute. The 1971 consent decree does not permit this. So what does Philip Morris have if it's not that? And I think the key here is to pay attention. Where was the permission granted? They've put hundreds of pages in front of you. It's certainly not the
So,
1971.
Heyman, what do you say to the argument that, excuse me, Congress says you can't put anything more on the packages unless we tell you you can, and this isn't on the packages, the tar and nicotine numbers?
That has nothing to the issue here is permission. The FTC would have had to give them permission to do it. Whether Congress says you can or can't require additional statements on the package, the FTC says you can't use this term. That's a prohibition. Not even Philip Morris contends that
okay.
you can't
So-
prohibit.
so-
We have to find a source of permission, and we know it's not the 1971 consent decree. So what is it? What is it? They say now, for the first time in their reply brief here, it's this 1967 policy statement. It's very important that the court go back and look at it. It's Exhibit 80 of your CD that's supplied there. You don't actually have it in the paper record. In that statement, and remember, there are only two things that Philip Morris has said give them permission. The consent decree, which we've covered, it doesn't permit it. Now we're down to the press release. The press release says, and I'm going to read from it on page 3, a cigarette testing relatively low or among the lowest in comparison with other brands may be so represented in advertising it to the public, provided that the basis for comparison is fully and fairly stated. That's what they said in 1967.
Yeah, but that goes back to the same question. Does advertising include cigarette packages? And you can argue it at least both ways. But let me ask
No,
you,
but, Your Honor, I don't have to prove that the FTC prohibited this.
you just have to prove that it didn't affirmatively
Exactly.
permit
This
it.
doesn't permit it. This
I
says you can say it if you
understand.
put the basis for the representation on there. They never did that.
Well, let me ask you
And-
this. If
and
your
the-
position is right, then why did the FTC never pursue American brands for not putting the numbers on their packages?
Your Honor, there are a number of agents. The Attorney General's brief talks about the discretion that enforcement agencies have. We can't infer, and this is really important because this goes to the heart of
I
the
suppose you would
Fleming
argue that that, again, is not affirmative action. It's just...
Your Honor, that's the standard. Okay, so we have two options. We have the 67 press release, which says you have to put the comparison on there. And there's an even bigger problem with the 1967 policy statement. The bigger problem is, at the bottom, it says, this is a necessarily cast in general terms, this policy, and we're going to have to work this out on a case-by-case basis. 1967. Case-by-case basis, 4 years later, the American Brands Consent Decree. What did they say when they looked at low tar representations in 1971? They said you can't use them unless you put the numbers on there. So the policy in 1967 was then clarified in 1971.
Well, what about in 1979 in the FTC report to Congress? The FTC, I believe, stated that, quote, cigarette manufacturers have never been required to disclose tar and nicotine content on cigarette packages.
That's right, Your Honor. But let's think about that's a red herring. They're saying there's no blanket requirement to put the numbers on the packs. That's not what we're saying. We're saying the FTC has not given them permission to use these words. You have to focus on the permission angle. They've never given them permission to use these words. The fact that they said you can't use these words unless you put the numbers on there is not a requirement that they put it on the packs. It's a prohibition. The FTC itself said it was a prohibition in the racketeering action. I want to just back up a minute, because I would really encourage the court to look at pages 1093 and 1099 of the Joint Appendix in 1997. There are two sections, Roman numeral I and Roman numeral II. Roman numeral I has to do with the testing, and it describes the FTC's involvement with that testing. Roman numeral II, a separate issue, has to do with the descriptors. And in Roman numeral II, they say they're beginning the process, that they have no official definitions. If you look at the Good decision in the First Circuit, the Solicitor General represented to the Supreme Court of the United States that they have no regulatory position with respect to these terms. The facts are that the FTC has never permitted the use of these terms. And that is the issue before the court on the 93A Section 3. Phillip Morris offered only two possible sources of permission, the 71 consent decree and the 67 press release. And I've explained why both of them are not relevant. I would like to take one moment to address the express preemption issue, while I may. I want to just say, if there's no other point I make with respect to express preemption, is that Phillip Morris, in its brief, concedes, as it must, that claims challenging false representations, false statements, are not preempted. We've alleged in paragraphs 3, 5, 6, and 56 of our complaint that these statements are false. Therefore, we are entitled to prove at trial that they are false. For you to find our claims are expressly preempted, you would have to prematurely rule on the merits. As the First Circuit put it, put the cart before the horse. Now, this is a backdoor approach to avoid a ruling on the merits, precisely because we know what happens when there is a ruling on the merits in the racketeering action. They were proven to be false statements in the racketeering action. We, as the First Circuit said in quoting the Mulford decision, courts do not determine whether a plaintiff can succeed on the merits of the fraud claim before determining whether the fraud claim itself is preempted. We're entitled to the opportunity to prove the statements are false. The federal government was given that opportunity and did.
Why didn't you bring a fraud? In other words, why did you only bring a 93A claim as opposed to, in addition, a fraud or misrepresentation
Your Honor, because
claim?
it's a class action. Common law fraud requires proof of reliance. Proof of reliance creates individual issues.
Okay. So if common law fraud requires proof of reliance and you don't intend to prove reliance, does that mean you don't have a claim of fraud? I mean, doesn't that affect your...
Because under 93A, under an intentional...
No, I understand you don't need it under 93A. What I'm trying to get at is the SIP alone question.
Okay. The duty behind the two claims, the predicate legal duty, which is what the Chip-Alone test calls for, the predicate legal duty of the claim is the duty not to deceive. It's the exact same duty in common law fraud.
So you say Chip alone is only dealing with those elements of the common law fraud that talk about deception, not the reliance. Is that your position?
That's absolutely true, Your Honor. In Chip-Alone, and the First Circuit has a very detailed analysis on this point, but the...
Can I go back to that, the case that's pending before the United States Supreme Court? What precisely is the issue in that case?
It's not pending. There's a certain...
I'm sorry.
Express and implied preemption only are pending before that
That's
case.
all?
Yes, the First Circuit's decision, not the Massachusetts law.
So it would have no effect on our state statute, obviously.
Right. Correct, Your Honor.
So there's really no point in our waiting for that.
Well,
Yes, Your Honor.
Those are arguments
Well, there is,
made.
because
Yes.
there's a double-barrel
Right.
Yeah.
argument here.
Yeah.
Let me ask you this. I take it then you disagree with Judge Laurier's implied conclusion that if they had only listed on the packets the amount of tar and nicotine, that this would be covered by the exemption.
Your Honor,
And that's what he's saying,
It's a hypothetical claim.
Not a hypothetical claim, it's a very important claim. Because that was why I was somewhat confused by your argument, because you're saying it doesn't matter.
Your Honor, it would definitely be a much more difficult argument for us to make, and I'm happy to say we don't have to make it. They didn't comply with the one condition placed on them in the 71 consent decree. Therefore, they had no permission. I see I only have a minute left, Your Honor.
You may concede the minute if you want to.
No, Your Honor, I'd like to just point out, for you to find that this conduct was permitted, one, you would have to ignore the language of the 71 consent decree. Two, you would have to ignore the fact that the 67 press release, whatever it said, was ultimately modified by the 71 consent decree, but it too required a basis for any representation of low tar. Philip Morris has admitted on 1291 and 1292 of the appendix that it never put that information with the representation.
But you say we would have to ignore the 1971 consent decree. No, we wouldn't, because it still comes down to the question whether in that consent decree advertising includes cigarettes.
Your Honor, but the point is,
And they certainly could have been a lot clearer than they
even if the
were.
prohibition didn't apply to packages, it didn't affirmatively permit it. I don't have to prove that it was prohibited by the FTC. I only have to prove that it wasn't permitted.
I thought you several times said that they violated the 1970. Am I wrong? Haven't you argued here that they violated the 1970?
Their actions were inconsistent with the 71
Well,
consent
that's a
decree.
little different than violating it.
It violates it if you think advertising applies to PACs. I'm granting Judge Cowan's question that it doesn't apply to PACs, but even if it doesn't...
I'm questioning it.
Yeah, well, our position is it does apply to PACs, but even if it doesn't, it still doesn't grant affirmative permission. And that's the key for this Court. You have to find affirmative permission, and it's not there. Thank you, Your Honor.
Thank you, Mr. Heyman.